This is Dr. David Shine, and welcome to Business Law 101. Now, what follows next is a set of 9 slides within Chapter 21 that focus on the difference between common law and the Uniform Commercial Code. These are areas where the Uniform Commercial Code is dissimilar from the common law. And so this makes it a little bit easier to remember because it's like, well, we know common law, most of us. Okay, here are things that we need to pay attention to because they're not the same as common law. So it helps you to learn the UCC at the same time. I wanted to mention that when I took my first business law course as a senior in college, and the professor, to my chagrin and sorrow, on the final exam expected us to memorize these section numbers, not just know this information, but actually know which section number. I've never thought that that was a particularly good way to teach any subject like this, where the key element I want is for you to understand this stuff. And then these specific numbers you can look up if you need to as you're going through this material in your day-to-day business practice. So, I mean, it's a very interesting situation, but again, we want you to focus on the concepts and not on necessarily the numbers. Again, they're all under Uniform Commercial Code Section 2. Again, comparing it with common law. In common law, we want a comprehensive contract. Uniform Commercial Code says most of the terms are there and we can kind of figure the deal out. It's okay. Now, I want to underscore here right up front, this doesn't mean it's really okay. It just means you can have an enforceable contract for goods under UCC that does not meet the common law standard for contracts. However, if you get to that point of the dispute, you've pretty much already lost. So from my book, we want to write contracts that are very comprehensive, that cover the waterfront. So the fact that you could do a little bit less doesn't mean you should do a little bit less. Firm offers by merchants are irrevocable for a maximum of 3 months. Again, most of the time, as long as it's reasonable, merchants have learned to put in a expiration date on their offers. In common law contracts, the acceptance is generally made by the way the offer is made to you. So if you are offered something by email, you're expected to respond by email. UCC says, we don't really care as long as you get the message back to the offeree, the offerer. And then unilateral offers may be accepted either by a promise to ship or by the shipment. Again, boo hiss, we don't like unilateral offers. We don't like unilateral contracts. One of the things to know is failure to reject may constitute acceptance, but acceptance by performance requires notice within a reasonable time. Again, not a big fan of acceptance by performance. We like to see fully executed contracts where the other side has said, yes, we are going to perform. That's what we like to see as business people. And then the variance in the terms between the offer and acceptance may not be a rejection and may be acceptance. Now, here's a critical element here with regard to Section 207 is when you have this situation in common law, remember we talked about the mirror image rule. The terms of the contract must directly meet the terms of the acceptance, mirror image rule. Key point here is the UCC does not require the mirror image rule. Again, not necessarily a great way to do business, but it means the contract may be enforceable even if it's not a mirror image acceptance. So watch out for that. Rather surprisingly, the price need not be included in a contract as long as you could figure it out through course of dealing or some other mechanism. Some other issues may be left open. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.